2 of LACERS Estate Planning webinar. Today we will feature 3 speakers, Erica, Claudia, and Janet. So next we will have Janet. Janet has practiced in the area of elder law for the past 32 years. She was formerly the director of the Family Caregiver Project at Bethesda Legal Services. Ms. Morris currently has her own elder law practice where she finds solutions to family crises involving long-term care. Ms. Morris serves on numerous local and statewide committees as a technical advisor to many projects concerning the legal rights of elderly and incapacitated individuals. She has co-authored numerous articles and publications, including the Caregiver Companion, and has delivered hundreds of speeches in both English and Spanish. Janet has received awards from AARP, KCET, Skirball Foundation, MAPS Charities, and the California Council for Gerontology and Geriatrics, and Alzheimer's Los Angeles for her professional contributions in this area. Janet and her 2 colleagues, Sarah Gelberg and Anant Lewis, formed JSA Consulting to provide education and consultation to working and retired caregivers. Janet received her BA degree from the University of California, Berkeley, and her JD degree from the University of San Francisco. You may visit Janet's website to learn more at www.janetmorrislaw.com. Now we will have Janet.
Thanks so much, Stephanie and everybody. It's nice to see everybody here. What a wonderful gift. Erica and Claudia did such a wonderful introduction to legal and financial planning for the future. I think everybody here is on the same page. We have to plan. And we've talked a little bit about why we need to plan. For some reason, I'm not being able to.
You can put your pointer on the screen on the what you need to know, and then maybe tap the enter button.
Okay, thank you.
You're welcome.
Okay, so they did a great job of introducing why we should plan. So let's talk about who should plan. Anyone and everyone who's over the age of 18 should make a plan that we were talking about earlier, which is including powers of attorney, wills, trusts, etc. So you don't have to be old and you don't have to be unhealthy or have a compromised health situation to plan. Everybody should healthy and health challenged. Also, if you are in a traditional relationship or a non-traditional relationship, it's still important to plan. And that's because, like was said earlier, just because you're married doesn't mean your spouse has legal authority to make decisions for you. But in practical terms, doctors and hospitals will ask the next of kin, but if you're in a non-traditional relationship, you do want to have that in writing, so it's very clear about who you want to make decisions or speak on your behalf in case you become incapacitated. And also people who have few relationships, it's very important for them to plan because there's not an obvious other person around who might be able to give the information that's necessary at the time that is needed. So it's a good idea to put whoever you want in writing. And that's what we're talking about when we talk about legal planning. We talked a little bit about this before, but why plan? We're getting older, we have accidents, we have the unexpected. COVID is a perfect example of why everybody should have had a legal plan. What if I got sick with COVID and ended up in the hospital on a respirator? I would be incapacitated because they pretty much put you under with pain pills, pain medication, and sometimes in a induced coma so that you can breathe freely with the respirator. And so you would not be able to pay your bills, sign your documents, talk to your landlord, talk to your employer. And you really, people who are in the hospital under those conditions need somebody who's authorized ahead of time in writing to make decisions. Now, most people who are in that situation probably didn't have any planning in place. So what happened? The hospitals probably talked to their nearest loved one who showed up to the hospital. That may not have been the person that you wanted, to be the one making decisions. So it's up to you to plan ahead, to put in writing, make it legal, who you want to make decisions for you if you were ever in that situation. Again, I said, stuff happens to people. I had a call on Saturday of a family of a 25-year-old woman who had a stroke and was, considered brain dead in the hospital. And she had a sticker on her driver's license to say she was an organ donor. And the hospital wanted to harvest her organs, and the family didn't want them to do that right away. They wanted to see if they could do anything for her. So there was quite a conflict there between the hospital and the family. And they still should follow the family's wishes. And the directive would be that the daughter wanted to donate her organs, but it still would have been better if she had signed an advance directive to say who she wanted, who would be her agent to make decisions about why and when and how that would happen. But I think they were using, control over the family who spoke Spanish and didn't have anything in writing to kind of push their whatever view they had about the donation of organs. So very, very important, another reason. And like I said, if you don't plan who you want to have authority, somebody else may be the one stepping in, and it lets you have control. And as Erica said, it's about you being able to speak after you can't speak. So if you're incapacitated, you can't say, wait a second, I don't want Mary, I want Lucy to make my decisions, but Lucy's in the hospital. But Mary's in the hospital. So if it's in writing, then it's your voice that's speaking. Okay, so what is in your plan? So this is what we talked about a little bit before. These are things that should be in your estate plan. So they would include a power of attorney for finances, and we're going to go over these things. Power of attorney for healthcare, also known as an advance directive, which Erica talked about. A living trust. A transfer on death deed is a newer document that you could think about. Bank accounts, how they're titled and who the beneficiaries are. Life insurance, also who the beneficiaries are. Disability insurance and long-term care insurance. So what's in a plan? So if we're talking about the things that are going to take effect after death, they would be wills, because that gives away your property after death. Life insurance benefits, it gives cash to someone after death. And a living trust gives your assets that are in the trust to your beneficiaries after death. Sorry about that. And a living trust, which gives your beneficiaries your assets after death. So we're going to go on. When should I plan? Now, it's never too late to plan. They were talking about earthquake planning on TV the other day, and we know there's probably going to be an earthquake sometime, so everybody should think about putting your shoes next to your bed, having water and food in your house or in a place that you could access it, having somebody to call when that happens. The same is true with life care planning, right? So you don't know if somebody in your family is going to trip or fall, or if that happens to you, a skateboard, bicycle accident, you just don't know what's going to happen. COVID, obviously. So now's the time. It's too late to plan after you're already incapacitated. So the poor woman, 25-year-old who's in the hospital, she can't sign a document now. The people who are on respirators in the hospital can't sign documents anymore. And also, even if somebody did have capacity, I had lots of clients who were in nursing homes at the time COVID hit, and they wanted to do documentation. And some of the documentation requires notaries or witnesses. But as Erica said, hospital employees can't be witnesses, and notaries can't get into the nursing home. So now is the time when you have We have a window of opportunity here. We need to use it. Okay, so this is the threshold question. Who has capacity to make decisions? It's a question that every attorney faces when they're helping a person with their documents. A lot of people come to us when they're already quite advanced in age, and also when they may have already had a diagnosis of Alzheimer's disease or some other kind of incapacitating event, but are still could be capable of making decisions. So there are laws about this. And by the way, I'm talking today about I'm talking about today is California law. Probate, estate planning, powers of attorney, conservatorships, wills and trusts are all part of California's probate code. We have 50 different laws in the United States. These are state law driven, not federal law driven. So every state has different laws. And I'm talking to you about California law. I don't know about every other state's laws. I know about some other states' laws, but today I'm talking about California laws. And that means that when you when you sign documents and choose documents, you need to sign documents that are approved and legal in California that go according to our laws in California and not other laws, other states' laws. So legal and financial decisions we're going to talk about those decisions, and then healthcare decisions. We talked a little bit about that, but I'll go over that again. And the Due Process and Competency Determinations Act is the California law that says who has capacity to sign documents. And basically, you'd think with a long title like that, it would be very specific about who has capacity and who doesn't have capacity, but that's not the case. So the law in California is you have to understand the thing that you're signing at the time that you're signing it. Okay, what does that mean? So if it's an advance directive, that's a pretty simple document. It means that you can choose who you want to make decisions if you became incapacitated. So even if you've been diagnosed with dementia, even if you're 99 years old and are hard of hearing, if I can communicate with you and you can tell me who you want to make healthcare decision for you if you became incapacitated, and you could, even if you couldn't speak, you could write it down, okay? Or there's some other way for you to communicate with me, and I know that you understand the question and that you have considered the answer. That is legal capacity because you understood the thing at the time that you signed it. You also don't need to physically sign a document. You can make an X. Okay, or if you've had a stroke and you can't sign with either hand, you could then direct somebody to make an X for you or to sign your name at your direction. So there's a lot of different ways around, but a lot of people don't know what the legal specifications are. So they'll say, no, you can't do it, but that may not be true. So you need to talk to a lawyer if you're in a very specific situation where there's, some hesitancy about it. Also, legal and financial decisions, same rule applies. You have to understand the thing that you're signing at the time that you're signing it. So if you were diagnosed with dementia and you owned a lot of property and businesses and things like that, and somebody wanted to buy all your assets from you for $1 million, let's say, but they were really worth $100 million. Do you really understand what you're signing if you're ready to sign that document? Maybe, maybe not. You need to have maybe a capacity declaration. You need to have a doctor. So if you have some kind of incapacity and the stakes are really high, like there's a lot of money involved, it's much better to have a doctor do a evaluation and write a capacity declaration on your behalf to say that, yes, you understand these legal and financial decisions. So it's kind of a little bit of a moving target. And the law does say that even if you have a diagnosis of dementia or some other debilitating disease, it does not prevent you from signing a legal document, as long as you understand what you're signing when you're signing it. Okay, so a lot of these categories that we're talking about, like powers of attorney, are called surrogate decision making. So you're appointing an agent or a surrogate to make decisions on your behalf. So that's what surrogate decision-making is, somebody else making a decision for you. And there's many tools in our surrogate decision-making box, and that's what you want, to have a full panoply of tools that you can use so that anything you need if you became incapacitated would be handled. So the first one we're going to talk about is the power of attorney for finances. And the one that I like to use, the document that I like to use, is called the Statutory Form Durable Power of Attorney for Finances. Statutory means this is a California document, and it complies with the probate code statute, which basically says that any third party, like a bank, like LACERS, like the Department of Treasury or the IRS, has to acknowledge that this is a legal document, because that's what, unless they think that there's some fraud involved, this guarantees that the third party can't say, no, 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 you didn't use our LACERS document. This, we're not allowing any other document but the LACERS document. Or Bank of America says, no, 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 you didn't sign your power of attorney on our power of attorney form. So we are not going to acknowledge this. Well, this by in and of itself, because it's the statutory form power of attorney, requires those third parties to acknowledge this unless they think there's some kind of fraud or undue influence or something like that. So as you can see, the principal, which is the person giving the power, puts their name at the top. I, Janet Morris, appoint Stephanie Smith. I think Stephanie's a great person. I think she's very responsible, and I want her to be my agent. So I appoint her as my agent, also called attorney in fact, to act for me in any lawful way with respect to the following initial subjects. So they would be different kinds of things. Real estate, so Stephanie could buy and sell my house. She could rent my house out. Tangible personal property, she could sell all of my pictures and furniture and antiques or whatever I have. She could conduct my stocks and bond transactions. She can do my banking. She could do insurance and annuity transactions, estates and trusts and beneficiary transactions, claims and litigation, personal and family maintenance, Social Security benefits, Medicare benefits, Medi-Cal benefits, retirement plan transactions, tax matters, or all of the above. So if I'm thinking ahead and I want to appoint somebody who's going to take care of all my business, I totally trust them. And by the way, that's the most important thing. And when you're deciding who's going to be your agent, is somebody who you think is the most trustworthy person and knows kind of how you like to conduct business. Are you conservative? Are you, do you like to give away money to charities? Whatever you think suits you, you can appoint that person. And if you're thinking ahead, you might say, well, I don't know which one of these they're going to have to do. So I'm going to put all of the powers listed above. So that's why if you trust the person, you can feel okay that you're giving them so many powers. So this is a very, very powerful document, as you can see. So it's really a power to steal from you too. Although an agent legally is only allowed to use your property for you, not for them. So they can't just transfer money to themselves and use it and go buy a house, in the Bahamas or somewhere. That would be fraud. They might try to do it and they might even do it, but it would be fraud and they would be subject to, criminal penalties for that and civil penalties. So that's what a durable power of attorney for finances is. It's important because you may need somebody to handle your affairs when you become incapacitated. This power of attorney, it stops on your death. So it will take no effect after your death, only during your life. Now, again, like the LACERS power of attorney for those benefits, you could say this power of attorney shall take effect upon my incapacity. So it's a springing power. That agent, Stephanie, has absolutely no power while I still have my marbles, only when I become incapacitated. Okay, so this power of attorney shall take effect upon my incapacity, and my incapacity shall be determined by my primary care physician in writing. So I don't put Dr. Smith, I put my primary care physician in writing because I don't know who my primary care physician is going to be when I become incapacitated in the future, let's say 10 years or 20 years. Or you could say, this power of attorney is effective immediately and will continue until it is revoked. And then this is the magic durable language. Okay, so this power of attorney will continue to be effective even though I become incapacitated. If you go to another state, you may find a power of attorney that's not durable. It doesn't have this magic language. And that means, let's say you give a power of attorney to Stephanie today and it's usable today, but I become incapacitated. And if that document does not have durable language, then it stops upon my incapacity. So that's the wrong kind of, you don't want a general power of attorney, you want a durable power of attorney. Okay. Now let's go back for a second if I can. Well, anyways, what I wanted to say was you could choose different powers if you want. So let's say you're going on vacation and you're in the middle of a refinance of your house and you do not want to delay your vacation to wait for the mortgage company to give you the documents to sign. So you can give over a power of attorney just for that specific act. So I give a power of attorney for my sister to sign all my refinancing documents with Wells Fargo. And then I could go on my vacation. And if during my vacation, the documents are ready, my sister can sign all those documents saying she's signing as my power of attorney, and they will ask for the power of attorney and she'll show them the power of attorney and that will be fine. Okay, more tools in the toolbox. We talked a little bit about some of these. So we have bank accounts, and in a bank account, I have my bank accounts, let's say in my own name, Janet Morris. That's how all my bank accounts are titled. If I put somebody on as a joint holder of my account because I think, okay, I want my daughter, let's say if I became incapacitated, I want my daughter to be able to handle that account. So my friend told me, oh, just put your daughter's name on the account and then she can handle that account when you are incapacitated. Okay, if I put my daughter on my account, she's an owner of the account. So a joint account holder, let's say husband and wife, you both own the entire amount. So if there's $50,000 in the account, husband and wife, husband could take out the $50,000 without the wife's permission, fine. It's community property. Wife could take out the $50,000 without the husband's permission. Fine. There's no issue of fraud or stealing or anything. If I put my daughter on that account as a joint account holder, Janet and Alyssa, she could take all $50,000 out, no problem. She's an owner of the entire account. So if you just want to protect your account because you want somebody to be able to manage your money, write checks on your behalf, okay, and not give them ownership of the account, then you do not make them a joint owner. You do not put them on the account as an account titled holder. You make them a power of attorney of that account. So how do you do that? You sign a durable power of attorney, and that person can go to the bank and say, I'm the power of attorney, please let me manage that account. Or you go to the bank and you say, I want my daughter to be my power of attorney on this account. And they say, here's a card, sign the card, daughter signs the card, she's legally power of attorney on that account. Okay, so that means that she can now sign checks, but she can't make checks to herself. She can only sign checks for me. So she can pay my bills. She could sign a check to the IRS. She could sign a check to my landlord. She could sign a check to my mortgage company or whatever it is that I need her to do. But she's not an owner of the account, so she can't take money out of that account, okay, for herself. And the same way is if she got in an accident and there was a judgment against her because she didn't have enough insurance or whatever, if her name was on my account as a joint holder, that party who has that judgment can get the money from that account because her name is on it. So you want to be very, very careful whose name is on what accounts. Let's talk a little bit about Medi-Cal in this context. I had many clients who had joint accounts with their kids, okay, but it was all their money. So let's say an 80-year-old had a 60-year-old daughter on the account because she thought that would be protective for her, that the daughter could take over if something happened to her. Well, I'm sorry, let me switch that around. The daughter, in this case, the daughter was 60 and retired, and she put her mother's name on the account, who was 80 but was on SSI. And the mother had Medi-Cal and ended up in the nursing home and the Medi-Cal said, no, you have 50,000 in your account. And the mother said, no, that's my daughter's money. She just put me on that account. But Medi-Cal will look at any account that you have. And if you have over 2,000, if you're a single individual, if there's over $2,000 in that account, you're not going to be eligible. So you want to make sure for judgment purposes, for prevention of fraud purposes, and also for Medi-Cal purposes, that you make sure that your name, only your name is on the account and nobody else's. And if you want somebody else to handle your account for you, you make them a power of attorney on the account. Now, what if you have your daughter's power of attorney on your account and you want her to get the money after death, after your death? Okay, and you want to give her all of the account after death, then what you do is you sign a POD on your account, pay on death, or a beneficiary designation. So that's the way you get the money to your daughter after death without going through probate. Okay, so any individual account you can make a beneficiary of. All right, and that's called a pay on death. So you have to consider each thing very, very carefully. Now, we'll get into living trust and how that's different from some of these tools, but this is how you title individual accounts to protect yourself. Don't put a joint account, somebody as a joint account, unless you intend for them to own the whole account now with you, okay? Now, what is a representative payee? A representative payee is someone who is managing a Social Security account for you, SSI, Social Security, or VA income, all right? So if I'm getting a VA pension in my name, and I have dementia and I keep losing my money or misusing my money or things like that, somebody else can become rep payee for that pension. The same is true for Social Security and SSI. Okay, so a lot of times people who have psychiatric disabilities or other kinds of disabilities or dementia, they need someone to manage that income, that check that comes in and gets deposited in the account, and then it's gone without the person paying their bills and they get into trouble. So a quick fix for that is somebody, again, a trustworthy person, family member, friend, or fiduciary who can become the rep payee. Then Social Security doesn't pay me my pension in my name anymore. It goes to, let's say, my daughter. So my daughter becomes the rep payee for me. So then she takes that check that's in her name. It says Alyssa Morris for Janet Morris. Then she opens a new account in her own name, Alyssa Morris. It's called a rep payee account, Alyssa Morris for Janet Morris, and deposits those checks there. So a lot of times when I use this, just to give you an example, is an elderly person who was fine for a long time, but now has dementia and is misusing their funds. So, and the landlord hasn't been paid and the bills have not been paid. What can they do short of conservatorship? If that person doesn't have a power of attorney, they can request a rep payee and start a new account. And then from then on, the rep payee, which acts like an agent of a power of attorney, can pay all my bills because they're managing the account. Well, we can answer questions about that later, but we're going to move on. So living trust, I know this is a lot of people have questions about a living trust, another tool in the toolbox. So a living trust is another way of managing your money, okay? And what you do with a living trust is you create this trust to substitute for you as an individual. So instead of myself owning my property and my bank accounts, I'm gonna go to an attorney and create a living trust. And then the living trust is gonna hold all these assets, and it's going to be managed by the manager of the trust, called the trustee of the trust. And why do I do that? For one simple reason. So that when I die, I don't own anything myself, and therefore it doesn't go through probate. I don't leave an estate that has to go through probate, which takes a lot of time and a lot of money to get your assets to your kids. So in order to get your assets to your beneficiaries or your kids quicker when you die, it's to put it in a living trust so that trust can then distribute it instead of it going through the legal process of probate. Okay, so we create a living trust, and it's documents which say who's the trustor, who's the one making the trust, who's the trustee. So here we go. I'm the trustor, Janet Morris. I'm making the trust. I'm going to fund the trust with all of my assets. So instead of being in my name alone, it's going to be in the Janet Morris Revocable Trust. And then I also name myself as the trustee. So I'm managing the trust. As long as I have capacity, and as long as I'm alive, I'm going to manage the trust. So I also will name a successor trustee, okay, which is my kids will, or my friend can be my successor trustee, which is the manager of the trust. Okay, so that means that while I have capacity, and then I'm going to name, sorry, my beneficiaries, which are my kids. So while I have capacity, I'm going to live in my house, I'm going to pay my own bills, I'm going to buy stocks and bonds, I'm going to invest money, but all of those assets are in the name of the trust. How did they get into the trust? They actually had to be transferred. Title has to transfer from Janet Morris to the Janet Morris Revocable Trust. Now, you know, if you have a trust, if your house is in a trust, means you've been to an estate planning attorney, okay, and then your house was actually quitclaimed into the name of the trust. And if you look on your property tax bill, it'll say TR, trust, or if you look at your bank account, it'll say TR or trust on it. That means you already transferred your property, and you made a trust and you actually transferred your property into the trust. What if you made a trust and you never transferred your property into the trust? It still stayed in your own name. Well, then the trust has no value, it has no use, okay? And it's not going to transfer those things after death. So you have to make sure that when you make a trust, you transfer the property into the trust. Now, the trust does two things. So one of the things I already told you, it distributes all my assets that are in that little bubble in the trust after my death. The other thing it does is if I became incapacitated, my successor trustee could step up and manage all those things. So the successor trust, it's like a power of attorney in that I have somebody, a surrogate, my successor trustee who's going to manage all those things in my life if I become incapacitated. But I also have, it's like an executor of a will. The successor trustee will, after my death, distribute all those things to my beneficiaries after I die. Now, just like a will, okay, my creditors have to be paid before my beneficiaries get anything. Okay, so the trustee, one of their duties is to pay my creditors, to find out if I owe money to Macy's or any other creditor that I might have. Okay, and that's what they do. I do want to say that I'm talking about a revocable living trust. There is such a thing as an irrevocable trust, which means I can't change it. A revocable living trust, I can change any time before I become incapacitated or before my death. I also want to mention that in the power of attorney document, that's also a revocable document. So you can revoke it anytime. That's very, very important for all of your documents to be revocable because you may get divorced, you may have a death, you may be estranged from your kids, you may get a lot of money, lose a lot of money. So there's a lot of reasons why you might want to revoke or change, amend your documents. And it's a good idea to look at these documents when you have a life cycle event, a birth, a death, a divorce, etc. You also should look at it every 5 years. See, are my agents still the agents I want? Is my trustee and successor trustee still the people I want? Are my beneficiaries still the people I want? Is my doctor still the person I want? Okay, and if you move from state to state, you may want powers of attorney and other documents from those states. Okay, so these are documents that are important to have. So how much money should you have to do a living trust? Well, probably have a house and some significant assets like stocks and bonds and things like that. that you want to be sure are sort of taken care of by the same person, okay? And that can be organized and managed by the same person. If it's just a life insurance policy, you have a beneficiary. Anything with a beneficiary does not go through probate, okay? And anything that's left over that's not in the trust is going to go through a will, okay? And if you don't have a trust, when you die, your property will be distributed according to your will, or if you don't have a will, according to the state of California laws. Okay, so and we'll get into wills in a minute. Once you have a trust, keep it where others can find it. Usually when a lawyer, an estate planning attorney does a trust for you, they do not only your living trust, but they do powers of attorney and a will also, and advance directive. So they usually give it to you in a 3-ring binder. And most people put that 3-ring binder on a bookshelf, and that is perfectly okay, because so many people call me and they say, my mom had a stroke, she's in the hospital, I need to get a conservatorship over her. I'm like, do you think your mom has a living trust? Did she go to an estate planning attorney? And they're like, yes, I think so. And I said, well, your mom probably already decided and put in place the powers of attorney and the living trust to make you the agent and the trustee if she became incapacitated. So why don't you look for that document? Go to her bookshelf and look on the bookshelf and see if there's a 3-ring binder. I cannot tell you how many times they call me back and they say, oh yeah, I found it. So I say, open it up, look in there. There's 4 tabs: power of attorney for healthcare, advanced directive, power of attorney for finances, and living trust, and a will. I say, so look at the advanced directive. Is your name on it as the agent? Yes. Okay, well then give that to the doctor. Look at the power of attorney for finances. Is your name on that as an agent? Yes. Okay, take that to the bank. Okay, look at the living trust. Is your name on it as successor trustee? Yes. Okay, so you don't need a conservatorship. A conservatorship happens when you don't have any of these documents and you have somebody who's incapacitated and they need somebody to act on their behalf legally because they didn't do the legally binding documents that we're talking about today. So again, if you do a living trust, let your agents know where it is. Okay, and where your documents are. They're probably on the bookshelf. You can also put it in something like this. You know, that checklist that Erica's going to give us. You can put everything, if you don't have a binder or your attorney didn't do that, put your documents in something like this and put it on your bookshelf so that people can identify it, who know about it, okay? Review, like I said, at life cycle events to make sure that the people are still who you want them to be, and amend it when it's necessary, and use a reputable lawyer, okay? You go and seek out, get reputable referrals from friends and relatives, your EAP program or whatever. They should be able to send you to attorneys. You can call the LA County Bar Association. They can have an attorney referral service. Sometimes the Los Angeles Asian American Bar Association, the Latino Bar Association, a lot of bar associations have referral services where you can find probably reputable attorneys and look for an estate planning attorney. So that's how you should get a living trust. You should not do it online. You should not get powers of attorney forms online. You shouldn't, because they could be from other states and you don't want that. We will have time to answer questions at the end, but let's talk a little bit about wills. So if you always need a will, even if you have a power of attorney, even if you have a living trust, you still need a will, because what if you acquire something, you inherit money or you inherit a piece of property and it's in your name, because it was transferred to you, but you never got into your living trust. Okay, so when you die, it's going to be titled Janet Morris and not Janet Morris Living Trust. So that means that it's going to have to go according to a will. So you always want to have a will, and you may not have much, so you're going to do a will and you don't think you need a living trust. So you could acquire something and you want to make sure that it goes according to where you want it to go, okay? Not according to maybe the state of California wants it to go. So a prepared will means you go to an attorney and that person writes a will for you. And it says, I, Janet Morris, make this my last will and testament, okay? And you say who it goes to. So I want $10,000 to go to Alzheimer's Association. I want $100,000 to go to Betsedic Legal Services. And I want the rest to go to my kids. Or the opposite, I want everything to go to my kids equally, okay? Or I want whatever it is you want. Let's say you have no kids. I want everything to go to the SPCA. Okay, you have the right to decide where your money goes and where your property goes. And whatever your last will says is where it's going to go. Okay, you can also have what's called a statutory will. That exists in the probate code. It's a form. The statutory will is a form. And it says, I give, and also with a prepared will, you could disinherit people. You could say, I give $1 to my son, George, because George did nothing for me during my life. And because you named him and you gave him something, he can't say afterwards, oh, my mom forgot about me. So if you had 4 kids and you only made a will and you gave 3 kids something and you forgot about George because you wanted to disinherit him and that's how you thought you did it. If you don't name him, he could say, I'm a pretermitted heir. My mom forgot about me and I should have 1/4 of the estate. And the court will probably side with him. But if you give George $1, then you didn't forget about him. He's not a pretermitted heir. So he's not going to get 1/4 of the estate. He's going to get $1. And you can also say anybody who disagrees with this is going to get cut out completely. So you can make that kind of a statement in there. So really, a will is where you could do a lot of, you could do whatever you want with your money. And you may, when you write your will, you may have $10, but when you die, you may have $1 million. You never know. Okay, so you want to make sure that there's a section called the remainder section in a will, and it's not a throwaway. So if you think that, let's say you have not much when you make your will and you say remainder to, and let's say you think, well, that's kind of a throwaway. So I'll give my remainder, whatever's left after, my kids get their whatever, 10,000, remainder to Betsedic Legal Services, which is a 501c3 charitable organization. So when you die, if all of a sudden you inherited $1 million or you won the lottery or whatever, and you have $1 million and each of your kids got 10,000, guess what? 860,000, whatever, is going to go to Betsedic Legal Services. So your kids are going to be pissed off. So don't think that the remainder section is a throwaway. So the remainder should be whoever you really want your money to go to. So that's prepared will, statutory will. Holographic will. What's a holographic will? Holographic will is something that is all in your writing, in your pen or pencil, not anything printed. A prepared will is printed, you sign it, and it's witnessed by 2 people, not notarized. Statutory will, same thing. Sign it, witnessed by 2 people with their signatures and their address. A holographic will is completely in your handwriting. You date it, you say, this is my last will and testament. I give everything to the SPCA. You sign it, Janet Morris, you date it, today's date, and that's that is your legal will, okay? Which, if it's the last will that's found, that's dated the most recent, this will be the one that is probated, and it will supersede anything that came before it. So basically, you revoke wills by writing a new one. That's how you revoke a will, by writing a new one, okay? And what happens if you have no will at all, or the will that they found was deemed fraudulent, or there was some problem with it because it wasn't signed correctly or it wasn't dated and they can't approve that will, the state can't approve that will. If you die intestate, it goes according to the laws of consanguinity, okay, and the laws of intestate in California. That means if there's community property, half of your community property, and there's no will, your community property is all going to go to your spouse if you're married to that person on your death. And then your separate property will go half to your spouse, half to your kids. Okay. And if you have no spouse, it will go equally to your kids. And if you have no spouse and no kids, it's going to go to your closest living blood relatives. It means your children, your parents, your siblings, on and on and on. My own uncle received money from his cousin. There were two living relatives, and he was one of them, and she had like a $20 million estate. So in his 80s, he got a lot of money and was able to live in a fancy assisted living for the rest of his life. So you never know when and how you're going to inherit money. So it's very important to make sure that you put the people down there that you want to have. Can I get a time, Elijah? How much time do I have left?
Absolutely. You have about 15 minutes more to go, Janet.
Okay. So the next tool we have in our toolbox is called the transfer on death deed. And the transfer on death deed was created a few years ago, and it was just recently re-signed in our legislature to be able to transfer your house or condominium, some kind of real estate that you owned, to somebody after your death without having to put it into a living trust. So let's say the only thing you don't have much cash, you don't have much assets, you just have a house or a condominium, and you want to make sure that it gets to your kids after your death, and you don't want it to go through probate. So before we had the transfer on death deed, you had to put it into a revocable living trust. And then it would go to your kids, if that's who your beneficiaries were, after your death. Now, a transfer on death deed is something that it's a deed, so you can, it's a future springing document. So after death, you can say, my house goes to my kids equally upon my death. And that will be a document where you could, after the death, you show the death certificate, and the county recorder will then allow you to transfer that property to the beneficiaries after death. So it's revocable, it's done now for later. It needs to be recorded within 60 days of signing. There's no probate involved, and there's no Medi-Cal claim involved. So a lot of people hear that when they have Medi-Cal, that Medi-Cal is going to come and make a claim against their assets after death. That is true, but they don't make a claim against all your assets, only assets that are in your own name. So any asset that is in joint tenancy, any asset that is in a living trust, any asset like a transfer on death deed that goes to your heir upon death, they cannot make a claim against for the money that they paid during your lifetime. So only Medi-Cal can make a claim only against assets that when you die are in your own name and are subject to probate. So this is a good alternative to a living trust if you don't feel like you have enough money to do a living trust. A living trust costs about $1,500 to $3,000 to create. And, this costs a few $100s to go to an attorney to do, or if you feel like doing it yourself, you could do it yourself, but I would be very careful about doing any documents yourself without legal advice. Because this is your major asset. So you want to make sure it gets to where it's supposed to go. So another thing is, what happens if you don't plan? Very stormy weather ahead if you don't plan, because things could happen and you may do the will wrong, you may do the trust wrong if you do it yourself, or if you don't plan, you may not have a will, everything will end up in probate. and it's going to go to people who you might not want it to go to. So you want to be very careful. Now, I want to just talk about being subject to fraud or undue influence. Remember at the very beginning, I said capacity is very kind of squishy. You just have to understand the thing that you're signing at the time that you're signing it. And you could even have dementia and still sign documents. There's a lot of fraud and undue influence going on with elderly people. I see elders who the neighbor says, you know, you need help with groceries and transportation and things like that. I'll take you to the doctor, I'll take you to the grocery store, I'll bring you drive. But then I want you to make me the beneficiary of your will or your trust. Sometimes it's clear and it's a arm's length agreement, and the person who's making the document understands exactly what's going on, but may not tell their kids, for example, and then all of a sudden the person dies and the elder has given away all of his assets through a living trust or through a will to some third party who is just buying groceries for that person, where the family, if they had known about it, could have paid for that or could have, but where was the family? So there's a lot of, how do people really, when are they really have capacity to know about the advantages and disadvantages about what they're doing? Sometimes it's a lot more nefarious than that. I mean, people, get a blind person to sign a power of attorney and then sign the or a living trust with making the neighbor, the bad doer, the beneficiary. I mean, a lot of that happens all the time. And when anything like that happens or you think is happening, the best thing to do is make a report to Adult Protective Services, because they can investigate and make sure that that the person who's the elder who's making that change to their documents is doing so with a free will. So even if you have capacity, somebody could be unduly influencing you. Okay, saying if you don't do this, then this might happen. Like a caregiver says, I'm gonna put you in a nursing home, or if you don't do something for me. There's a lot of bad stuff that goes on, and a lot of it is actually within families where it happens. Some of it is caregivers, some of it is neighbors, some of it is really just bad doers, and some of it is family members. So we see a lot of fraud and elder abuse going on within families and also with caregivers. I'd say probably more than 90% of the elder abuse, it happens with people known to the victim, right? So it's never a bad idea to call APS. They will investigate. They won't share the information that they acquire with you, but if they investigate and they think that there's something bad going on, they'll share it with the police to do more investigation, or the DA, or whatever. I think I'm going to stop there and share with you. Oh wait, there's a little bit more. Okay, so what happens if you don't plan? Loss of control, we talked about that. Loss of opportunity, like Medi-Cal planning. Sometimes you can do things with your assets so that you can take advantage of Medi-Cal, because Medi-Cal pays for home care as well as nursing home care. And most people can't afford home care or nursing home care on their own. They need help through Medi-Cal. And Medicare does not pay for long-term care in a nursing home, only Medi-Cal does. And the good news is that Medi-Cal is expanding, and Medi-Cal is more of a middle income benefit than a low income benefit. So for example, if you're a couple and one spouse needs nursing home care or in-home care with in-home supportive services or daycare or whatever, you can have your house, a car, $136,000 in liquid assets and $3,000 in income and still qualify for Medi-Cal. So a lot of times, even the Medi-Cal office won't know those programs. There's 35 different Medi-Cal programs, and it is expanding because the governor just signed a bill passed by the legislature that's going to make Medi-Cal available to people regardless of how much assets they have. It's just going to be income-based. And that's going to go into effect between 2022 and 2024. So that was a really good expansion for people who need long-term care. And of course, if you don't plan, you may lose money and resources. Just in terms of probate, probate costs a percentage of your estate. And it's double that percentage of the estate because half will go to your executor and half will go, the percentage, a full percentage will go to your executor and a full percentage will go to the attorney for the executor for probating your estate. So there's a lot of reasons why you should do your estate planning. And just to reinforce it, anybody who you make your agent or your trustee, you should really, really trust and have a lot of faith in. And if you don't know somebody personally, there are private fiduciaries who can act as agents or trustees for you. And here's a list of caregiver resources. Alzheimer's Greater Los Angeles has a lot of resources. They also do some referral services for professionals in the area. Los Angeles Caregiver Support Center is wonderful if you are in a caregiving situation and you want more information. LA City Department of Aging, the Family Caregiver Alliance, National Academy of Elder Law Attorneys. If you need to do Medi-Cal planning and estate planning, don't just go to an estate planner, go to an elder law attorney, and you can find one at NALA.org. And then the best Medi-Cal information for California is at California Advocates for Nursing Home Reform. And of course, I should put Bedsedic Legal Services on there, although they do not do estate planning. They do have conservatorship clinics, self-help conservatorship clinics, and they do have advanced directive clinics where they can help you do an advanced directive. They do not do powers of attorney for finances, nor conservatorships that involve financial conservatorships. So this is some resources that you can utilize. And I know that we all will think hard about making sure that we have our plan, we put our plan in place, we let our plan known to our loved ones, and we know that we can always revoke those plans and change them if we need to. So thank you very much. I really appreciate talking to you today. It's been a pleasure and I look forward to your questions.
So Janet, we have a bunch of questions. So I've categorized questions for Elijah in the category of POA and then living trusts, living will and trust. And so he's going to read those out to you. But I just wanted to let the audience know that there's a bunch more that we're not going to be able to get to because of time. But what I'm going to do is categorize them after the presentation and send them to Janet, Claudia, and Erica and have them answer those questions and then email them out to everyone so that everyone can get that information. So I'll now give it over to Elijah.
Okay, thank you. We have some pre-questions that came in prior to today's presentation. We start with Peter. We are joint tenants, not married, with right of survivorship on our principal residence and rental property. I'd like to know, is it necessary to own one or both properties in a revocable living trust?
So the answer to that question is, when one of the joint tenants die, the other one will receive that property by right of survivorship in California. So you do not need a living trust if they're both in there. But if you have other assets and things, bank accounts and other things, where it might be better for that property to be in a living trust, and then the successor trustee can manage that, and it could go to the survivor but it would be taken out of joint tenancy and put in a living trust. So this is one of those things where you just have to balance. Individually speaking, any property that has a joint tenancy has a right of survivorship. So it's up to you to decide whether you want to put your property into a living trust or not. It won't, the way it is, it won't go through probate. And if you put it in a living trust, it wouldn't go through probate. So it's something you may just want to talk to a lawyer, an estate planning attorney about, to look at the holistic view of everything else you guys own together and not just those two individual properties.
Thank you. Our next pre-question is from Baljit regarding living trusts. Will this training help me to update the document I had about 10 years ago? If not, what is best, software or an attorney?
Definitely go to an attorney, go to the attorney who created that living trust if they're still around. And like I said, look at it every so often, make sure that everything is still the way you want it to be. And if you need to make amendments, let the attorney make amendments. If that attorney's not around, go to another attorney. And do not download software. You could easily make a mistake. And like I said, this is all of your assets that you're deciding what to do with. So I would be careful and make sure you have the advice of an attorney. And also you can ask them about tax issues and other things like that that may affect it.
Okay, great. Our next question is from Soli. What is the difference between a revocable and irrevocable trust and the tax consequences of each?
So I'm not a tax professional or tax expert, but a revocable trust, you can change at any time. It's taxed as if it were just you individually owning it. Okay, so there's no special tax for it being in a trust, and there's no savings for it being in a living trust. But an irrevocable trust, you cannot change once you make it. The other thing is it does freeze the asset value that's in the trust. So if you put a $1 million asset in the trust and then it became irrevocable, when you die, if that asset's worth 10 million, I don't believe you're going to pay tax on the increase in the value of the asset. And that's why people use irrevocable trust. But the downside of an irrevocable trust is you can't change it once you make it. So again, talk to an attorney, a professional, about what works for your goals and your assets.
Thank you, Janet. The next, and our final pre-question comes from Bill. There's 3 parts to this question. The first part is, can a 457B or a 401k be transferred into an estate?
I do not know.
Okay. Part 2 of that is, how are estate taxes handled?
Okay, so estate taxes are handled upon your death. If you're married, there's something called a step up in basis. And so the property that you own is going to be reassessed to a different, not reassessed, but revalued according to the date of death. And I think today you get $13 million each person free of estate tax. So most people don't have to worry about estate tax. Okay, it's just capital gain tax on a property that you own when you sell it after you die. Okay, but there's right now, if you bought a property at $100,000 and when you died, it was worth $1 million. You get what's called a step up in basis, so that the day of death, your property's now the base worth of $1 million. And when your heirs go to sell it and it's worth $1.2 million, they're only going to pay capital gains on the difference between $1 million and $1.2 million. If they sell it exactly after you die, there's no capital gains because it's going to be worth whatever it was, the basis was, which is $1 million. If they sell it $1 million, you're not going to pay capital gains on 100,000 to $1 million. It's just going to be $1 million. So that's a long way of saying, excuse me. That's a long way of saying, talk to your attorney about estate taxes.
Thank you, Janet. All right, now we're going to go into some questions. Before that, it's a little something from our chat. A big thank you, Janet, Morris, and everyone. It is so clear and so informative. It helps a lot. Thank you so much. So some accolades from the group. Now let's move on to the questions from the meeting. This is a general question. Can you please clarify the legal aspect of the living trusts, of a living trust? Is it like an advance directive?
Okay, so it is not the same as an advance directive. An advance directive is only regarding medical powers and medical decisions. Okay, so when you choose somebody in an advance directive, which is also known as a power of attorney for healthcare, okay, when you choose that agent then has the power, according to your previously described instructions, to have authority to make healthcare decisions on your behalf. That includes food and water, artificial means of nutrition, hydration, whether to consent to care, surgeries, cancer treatment, etc., and end of life treatment. Okay, so at the end of life, do you want to be kept alive by art? If you can't swallow, do you want to be kept alive by artificial means or do you not? Okay, and that's something that only your power of attorney agent can do and not something that a living trust trustee can do. So when you go to an estate planning attorney, you need all 4 documents. You need a power of attorney for healthcare or advance directive, power of attorney for finances, living trust, and will. Okay, and I just wanted to make, to clarify, end of life decisions. Your agent has the right, your power of attorney for healthcare agent or advance directive agent has the right to make all those decisions for you at end of life, according to the wishes that they know from you. So if you didn't specify anything in your 5 wishes about what kind of end of life care you want, there's something called a POLST, P-O-L-S-T, Physician's Order for Life-Sustaining Treatment. It's something that a hospital or doctor will ask you at end of life, or your family members or your agent at end of life, what type of treatment do you want? Do you want aggressive, everything available to be given to you? Do you want a trial period, or do you want nothing? So if you had a heart attack, do you want to have CPR or no CPR? Well, if you're 90 years old and you have dementia and COPD and heart disease, you may say, if I go in to have a heart attack, please do not resuscitate me. And then either you or your agent can sign that POLST, and then that's an order, like a do not resuscitate order. It's part of that POLST, so that you won't be resuscitated. If you live at home and you're not in a hospital and you're very elderly or frail or sick, you may want to do a POLST so that if the emergency medics come and they see do not resuscitate, they won't resuscitate you. It used to be called an emergency DNR order. Now it's called a POLST. And it shouldn't be used except for at end of life, when it's not unusual that you would die within 6 months. Not for everybody. Not for you and me that are, running every day. That's not what a POLST is for. Neither an emergency DNR. But we should have advanced directives. Okay.
Okay, great. Now we have POA questions from Miguel, Valerie, Eleanor, Cheryl, and Jeanette. Start with how to implement POA for married couples with separate and joint bank accounts.
Okay, so this would regard only the POA for finances, okay? So if you give your spouse, okay, let's say you have a joint account. That person doesn't need a POA to handle your account, okay? It's Janet and Bob, okay? If it's our joint account, Bob can do anything on the account, I could do anything on the account. But when I go to my estate planning attorney, I do want all those documents, including a power of attorney. So in my power of attorney for finances, because I'm with Bob, right? I say my agent is Bob and my alternate agent is Andrew, my son. And then if he's not around, then Alyssa, my daughter. Okay. So let's say I have that joint account. Bob dies. That account becomes my own account. And then I become incapacitated. So I've already done the power of attorney. Bob's dead. They go to the first alternate agent, Andrew. So I'm covered because now that account is in my name alone. My joint account holder is dead, and then my successor agent can handle that account. So it's still a good idea to have a power of attorney, even though you have a joint account.
Right. What is the difference between a general and durable POA?
Okay, so a durable POA lasts through your incapacity and a general doesn't. But these words are kind of, general could be used in many different ways in many different states. So you want to make sure that you have a durable power of attorney, which on the face of it says, this power of attorney shall stay in effect even though I become incapacitated.
Okay. A general question more, what exactly is a durable POA?
Durable POA is a legally binding document which gives your agent that you pick the power to make any decisions that you give them power over. So when I showed you that power of attorney document, that sample, it said real estate transactions, stock and bond transactions, bank account transactions, Social Security transactions, anything you choose, that power of attorney has authority over when you become incapacitated. Okay. And so if you don't put everything, it's only those things. So if you pick real estate and nothing else, then that agent doesn't have any power over your Social Security decisions. I hope that helps.
Do I need a general or durable power of attorney if I have a LACERS durable POA on file with LACERS?
Thank you for that question, because the LACERS power of attorney, durable power of attorney, is only for the specific pension plan issues. So it gives your agent the right to make pension plan elections or changes. It doesn't, the LACERS durable power of attorney has nothing to do with your property or your stocks or your anything else. It's just specifically for LACERS pension. And it's important to have it for that. But if you have a durable power of attorney for finances, that will substitute for the LACERS. The LACERS will not substitute for the durable power of attorney, generally speaking. Hope that helps, but you can have both. So do both.
In a similar vein, I live in Nevada and have a living trust. Will LACERS accept my POA associated with my trust?
I suggest you send it to their legal department and see if they will accept it. In any case, do a LACERS one so you're double covered. They already know that's acceptable. So as long as you have capacity, just do that one as well. But you can always ask them if your Nevada power of attorney is acceptable to them.
We're going to move on to questions on wills and trusts from Linda, Tam, and Grace. Do you have to have witnesses when getting wills and testaments notarized?
A will in California is only witnessed, not notarized. So if it's notarized and not witnessed, it's not according to the law. It should only be witnessed by two parties. They all have to sign at the same time you're signing.
Okay. Okay, here's a big one. What is the difference between a will and a living trust?
Okay, a will gives away property that you own in your name at death. A living trust gives away any property that's in the living trust at the time of your death. A living trust also allows the successor trustee to manage all of those things in your living trust during your lifetime when you're incapacitated or when you're not, depending on what the living trust says.
Okay. What should be included in a special needs trust if a person is on government aid?
Okay, a special needs trust is a special trust for a person who is disabled, a disabled adult. So a special needs, or child actually, anyone who's disabled who's on government aid, meaning SSI and Medi-Cal, if they want to hold any kind of assets, so they're under SSI and Medi-Cal, a disabled person is limited to having assets of no more than $2,000. So let's say the parents want to provide that child with special education services that are not covered in the public school system, or special computers, which is not covered by SSI or Medi-Cal, or they want to receive money for Christmas and birthdays. That child cannot receive or hold more than $2,000 a month. So Medi-Cal and SSI look at your bank account every month and make sure that you're not more than $2,000. If you are, you'll be kicked off of SSI and Medi-Cal. So if you create a special needs trust for a person who's disabled, that trust is handled by a trustee that's outside of that person's control. So the beneficiary, the disabled person, can't control what happens to that special needs trust. And then the parents can leave money when they die to that special needs trust, millions of dollars, hundreds of thousands of dollars, whatever. People can give bar mitzvah money or birthday money, and it can all go in that special needs trust, and it is not counted for Medi-Cal and SSI, and it can be used for that disabled person's needs that are not covered by SSI and Medi-Cal. How do you set up a special needs trust? You can do it through your own estate planning, so that when you die, your disabled son or daughter is taken care of, and it won't affect their Medi-Cal or SSI.
If both spouses are named as trustees in a revocable living trust, what happens if one spouse dies?
Well, the co-trustee should have the power to manage the estate. So that's usually how it's written. So every trust is written differently, and the responsibilities of the trustees are written differently. And you should always have a successor trustee, even if you have a co-trustee, because the reason you have a co-trustee is if one dies, the other one takes over, okay, automatically. You don't have to go do, there's things you have to do. There's documents you have to sign and stuff to get from a trustee to a successor trustee. Okay, it doesn't just happen automatically. You have to sign, there has to be documents signed. But when you have co-trustees, according to what you say in your trust, the co-trustee could probably just take over without any documents being signed.
Final question for you, Janet. You've been doing so long here. Do I amend the trust, my trust, by going back to the same attorney, or can I go to another one? You
can do whatever you want, but the point is to go to an attorney to amend your trust so that it is done correctly. So you can either go to the attorney if you were satisfied with that attorney, or go to a different attorney. But have them review all of your documents every so often, so you make sure that everything, and the documents I'm talking about are those 4 documents: advance directive, power of attorney for finances, will, and living trust.
Thank you for joining LACERS Estate Planning webinar. We look forward to you joining us for more LACERS events in the future.